Please be seated. Number 2, please come to the podium. Where's your...
I finished it.
Did you really?
Oh, yeah.
Wow. Okay.
It was good.
Okay.
Morning, Your
All
Honor.
right, morning. I'm sorry, what number?
Number 2 you want us.
Okay.
Your Honor, the court issued a writ of possession in favor of my client, who was the purchaser at the foreclosure sale. The sale took place quite some time ago. The title was issued to my client September 11th. The writ was stopped because Ms. Macklin, who's to my left, filed an affidavit with the sheriff saying that she had an interest in the property, a possessory interest, and wasn't noticed. When the sheriff gets those affidavits, they stop executing, so we were required to set a hearing this morning for the court to, our request, of course, is to have any stay on the writ lifted.
Okay. All right, let me hear from you, please.
So what the situation is when the new owners bought the property, it was never intended for sale. I talked with the owner the entire time. I had his number and email, and the arrangement was he wanted to just fix up on the property, but he had a hard time finding a contractor. This went on from about September to the end of the year. It wasn't until the end of November he was like he wanted to sell the property. I told him I'm not mad because I understand the situation. But the thing that dissatisfied me was he was saying that I give you 2 weeks to move, and I told him that honestly is not fair. Enough time to move. You're telling me you want to sell it now, and I have to be out in 2 weeks. That's not fair. I said I'm going to need at least about 3 months. At the time, my wife was transitioning to another job, and during the whole time when we was communicating, there was never an intention of us moving. We already established that we already paid all the utilities and take care of the property since my grandmother was deceased, because the deceased is my grandmother. I've been in this house since I was born, so I even told him, look, if you want to sell the property, I have no problem with that. I'm not mad. Just give me enough time to move. And with all the notices that came, like, we didn't even know that affidavit or anything was filed against us. Because when I talked to him, I say, look, it was my birthday was at the beginning of December. I told him, I said, look, my wife just transitioned to another job. Give me about 2 or 3 months. I'm like, I say you don't even have the funds to help me relocate, and I'm not mad at that. At least give me some type of notice that I can take to my job and let them know how severe the situation is, so they can help me. And they was willing to help me. But he told me no, he wouldn't even give me a notice in my job.
So you told me that it was in November that you were first told about this. So what have you done? Tell me what the situation is now. How are you going to be able to, where are you moving to and when?
Well, right now I found a place, but it's not ready yet. So the time frame I wanted to ask for was to the middle of March, because when I recently talked to the landlord, everything was full. I previously got on the waiting list within this time frame while the situation was going on. My wife just started a new job, and I'm going back and forth from like here, like outside of Miami, doing work for the same company I'm working for, just so we can have the funds to move. Right now, that's been our whole goal, and we was trying to move by the beginning of March. That's why I need at least to the 15th of March. And I know for a fact that even if it's not the facility I'm moving in, I can at least find another facility to relocate and move to.
Okay. Have you talked with them about the possibility of you paying rent during that time?
Yes, that's what happened.
When I first,
Hold on.
Okay.
When he first bought the property, I first mentioned that. I say.
All right. Have you talked with this
Fabian.
lawyer's client?
No, it was never involved. This is
Okay.
This is just
No, but you've had notice. You knew what was going on since November. So, all right. What's the situation as far as your client? They bought the house when the foreclosure property. So let me hear from you as to what's going on.
The title was issued September 12th, so I would imagine that these initial discussions have been going on since the mid-September, so that's about 4 months ago. I filed my motion for writ, Your Honor, and did a notice of hearing, and I served all persons in possession at the subject premises November 29th. So I think at a minimum, that's November 29th, today's January 30th, so it's been 2 months since they've known that my client wanted to get possession. I can't speak personally as far as what discussions they had. I don't think there was anything concrete or fruitful, but so I think that, this is not a situation where my client acted really quickly and they've had really no notice, no time. They're not tenants, they're family members, so it's not like they're unsuspecting tenants. They've known about the title since September 12th. They've known about our motion for writ since November 29th. My hearing was actually December 19th, so it's been about a month and a half since our title since the initial hearing. And we did give notice of the December 19th hearing to, again, all persons in possession of the property.
No, I
So,
understand that.
my client's
I guess
position-
my question is,
Yeah.
has your client talked with them? What's their, what are they gonna do with the house?
Well, I think my client probably wants to get possession to make any and all repairs to try to resell the property. I don't think they're looking to make it a rental. I don't believe so.
No, my question is, would they make it a rental just for a month or two?
It's possible. I mean, Your Honor,
All right, do me a favor.
yeah.
I'm gonna come back to it.
Okay.
Talk to your client out in the hall, let me know.
Okay.
I mean, here's the problem. The problem is that you all have known for a while about what's going on and still haven't moved out yet. I'm sympathetic to the situation. I understand it.
The
I
mail,
understand.
Your Honor, comes to, from his grandmother goes somewhere else to power of attorney, not to the 4911. So when you guys are sending something, it's getting
No, but
forwarded to
this
another
this
address.
was a foreclosure that took place a while ago. And so all I'm saying is, I'm trying to see if there's any way that they're gonna work with you all to give you a little bit more time.
That's
Technically,
all.
technically they're entitled to immediate possession.
And-
But
and
let
it
me
was-
see, he's gonna talk to his client. We're gonna come back and talk about it at the end of the calendar, okay?
I just have to check in
So-
with Judge Zilber's chambers.
Yes, go ahead.
I'll come
No,
back
we
up.
got time. We've
Okay,
got
thank
time.
you.
All right. We'll come back and talk about it.
Okay.
He's gonna talk with the client,
I'll
okay?
be right
All
back.
right, I got you.
Number 9,
Morning, Your Honor.
Morning.
This is the third party's motion for writ of possession, Judge, and no one's appeared today.
Yes, let me have an order, please.
Thank you. And then I have an agreed order on number 11. And this is number 11, it's an agreed order.
Number 11.
Yep, that's the next one.
Okay. Okay,
Thank you, Your Honor.
thanks.
Thank you so much.
number 3,
Hi, good morning. All right, this is on Fannie Mae and Klaus Betcher,
That's correct, Your Honor.
173562. All right, let me hear from you, please.
Yes, Your Honor, I requested this hearing because of the fact that the plaintiff is not producing their witness for their position, and this has been.
Are you
going
talking
on.
about Tana Walker?
Yes.
Okay. Tell me who Tana Walker is to this case.
Well, I don't know her. That's a witness they produced, and
What do you mean produced?
well, they took a affidavit of Tanya Walker,
Okay.
and
Is she going to be called as a witness at trial or not?
No, Your Honor.
What does she have to
Here's
do
the
with
thing.
anything?
We are on the same issue before Your Honor, at least I believe third or fourth time. Your Honor, previously, we moved for protective order previously because
Right.
this individual is not employed by the plaintiff.
I
It's
understand.
not- Your Honor explained before at the hearing that it would require subpoena without giving any legal advice if that's who the defendant wishes to depose. We have no control over this individual, and here we are again. And I believe the last order that was entered by Your Honor was in June, in May of last year. But we received this motion directing us that there was deposition scheduled unilaterally, once again, after Your Honor already directed that, granted motion for protective order. And
Did you subpoena the witness again or not?
well, yes, it's a couple of times, and they didn't respond. They just left us out in the cold.
No. They told you she's not an employee of their company.
Yes, well, I mean, even if it's an employee or not, they took an affidavit of their witness.
Yeah, but the responsibility doesn't go to them to get in contact with the witness. The responsibility is with you. Are we set
Well-
for trial?
no, Your Honor, we're not.
Why have we not been set for trial?
As of December 5th, there was service release from U.S. Bank as, to U.S. Bank as trustee NA for LSF11, Master Participation Trust. This was as of December 5th. We're waiting for the assignment of mortgage, Your Honor, on this one, so we can proceed with our motion for substitution of party plaintiff.
All right, well, let's put it this way. If have you all talked about a list of witnesses that you intend to call at trial or not?
No, Your Honor, the whole time it was this issue about Miss Tanya Walker,
Okay,
3 or 4 times.
all right.
And this is really yet the same attempt,
No, I read it, I have it in front of
Your
me.
Honor, and I have with me the last order, Your Honor, entered.
So let me go back to the original question I asked. Who is she to this case? Is she the person who had certified the or had verified the complaint? What is she in this case?
All I know, Your Honor, is that the person is not employee of the plaintiff and.
Who is she to this case?
I don't know. I mean, they took, the law firm here took an affidavit of Tanya Walker, and, if they are unable to produce their witness for the deposition, I would ask
It's
the
not
court
there.
to strike it.
There's. All right, that's denied. All right, the bottom line is they can produce. My previous order was that they coordinate with you on employees that are going to be testifying at trial whose deposition you want to take. All right? That's basically what my previous order was. You can do that and coordinate with that with them. And it says right in the order who it is that you're to be in contact with. If there are witnesses, she is not one of those witnesses. I've said that several times. Please, Mr. Betcher, we need to move this.
I contacted the attorney, and
I know.
I never heard anything from him.
But that's because you already know that Tanya Walker is not an employee of them. So,
How can they take an affidavit of a witness?
Mr. Betcher, please,
Yes.
I've asked you before, I would ask you again, please get a lawyer so that the lawyer understands the process. I mean, I'm trying to educate you as we go through this process, but it's
Thank you.
clearly not working, and that's probably on me. That's my fault, I'm sure. But, you're allowed to only take those the depositions of those witnesses that are employed by them and also who, please consider the possibility of getting a lawyer, all right?
Thank you.
All right, now, as far as, so this motion, it's actually a motion for a case management conference.
Exactly, Your Honor, so that's what
So-
my order is, but again, what's attached besides the notice of hearing for case management conference is in a letter form, but in essence, again, the same request what was previously ruled on.
I know. When are you all going to get what
was
it
as
takes so that I can sign the order so you can amend the complaint and we can move this along?
So it will be substitution since it's after the
Right.
file of the complaint, Your
Right.
Honor. That was on December 5th. The email that I received from the file attorney was as of yesterday. We didn't have it, but it should be very soon, maybe another month. I don't have a deadline,
All right.
but so it's
Well,
my guess, Your Honor.
because I've heard about it before and you've told me about it before, you know that I'm going to grant it. Submitted it. Make sure you let them know that it gets submitted in their proposed orders in Word format so they can do it.
Understood, Your Honor. Once we have the
All
documents,
right.
yes, Your Honor, will do.
And then the other thing is, I want there being a notice for trial. Let's get this to trial.
Yes.
Let's resolve this case.
Yes.
Okay.
And if, of course, we would like to know too from Mr. Brocher if he's interested in any.
How do I
roles.
pronounce, Sir? How do I pronounce your last name?
Bocher.
Bocher?
Yes.
Okay, I'm sorry. Mr. Bocher, I need you to talk with them. You've sent one email to them. I've noticed that's in the paperwork here. They're going to tell you after this gets set for trial who it is that they're going to call You can talk to those people before trial that morning, or you can set them for deposition and order it and get it all done and set up with them ahead of time, okay? But they're gonna
Okay.
tell you who that is. But Tana Walker is not a name that they're gonna be calling as a witness at trial. You know, I've got to see good cause from you to, and a legit reason as to why she should be deposed in this case, and I haven't seen that yet, okay? All right, thank you.
Your Honor, may I provide the order denying motion for case management funds, because that's what the motion is called, but if Your Honor wishes to, I don't know, if you would like to add any other, maybe a language addressing what we're here on as far as prior request for the position of, if you want me to.
Okay, all right,
Thank you, Your Honor.
thanks, all set, thank you.
Thank you.
She'll give you a copy of it, or we'll make a copy for you.
Number 6,
Good morning, Your Honor. Candace Solis from the
Morning.
Hamptons.
All right, this is on U.S. Bank versus Celebration?
U.S. Bank versus Pedro Estelar.
go.
Celebration is the client that I represent, yes, Your
Right,
Honor.
okay, 17-13265.
Correct, Judge.
All right, let me have appearances, please.
Jennifer Leal for the plaintiff.
Okay, all right,
And Candace Solis on behalf of Celebration Point Master, Your Honor.
right.
Judge, so this is our motion to vacate the sale that transpired on November 14th and to vacate the certificate of title that issued. And the motion reads that the basis is that the defendant was still in the appeal period when our motion to cancel sale was denied by the court. And the certificate of the sale occurs and the certificate of title is subsequently issued. The court, the plaintiff again seeks to vacate the sale and the certificate of title issued based on the Exhibit A, which is the October 16, 2018 letter from the servicer SPS advising that the defendant had a 30-day appeal period from the date of the letter. Accordingly, Your Honor, that is the basis for today's motion to vacate sale and CC.
Your Honor,
Did the
there's-
defendant appeal?
This is from a, this
The answer
appeal-
is no?
The answer is, I don't know.
That's a no. Okay, all right.
And I just wanted to point out, in addition to what plaintiff had mentioned, this is in response to a review application from 2014.
I saw that. I saw the
Okay.
date on that.
And in
I-
addition, Your Honor, this
Okay.
letter was presented to the court prior to the sale on a motion to cancel sale, which was denied by the court. So this was already reviewed, considered, and disregarded.
Oh, so now you're loading on to the.
I-
Okay,
Your Honor,
all right.
you don't
It's-
see
it's-
me.
The motion, the motion's
vehemently
respectfully denied.
Thank you, Your
Okay,
Honor.
thanks.
Judge, I also have number 15.
All right. 15.
It's a motion for writ of possession. Thank you. Thank you.
If I may approach, Your Honor?
Yes, ma'am.
Thank you.
Thanks. Okay.
Thank you, Your Honor. Have a great day.
Thanks, you too. All right, wait a minute, let me see. 17-7406.
Yes, Judge. This is U.S. Bank versus the unknown heirs of Wilson
Oh,
Pierre.
yes. All right, I see it. No, it's granted.
Thank you, Judge. It's in order.
Number 5,
Thank you. Take care of yourself.
Morning, Your Honor.
All right, morning. All right, let me see.
Picture.
All right, is there anybody else here in opposition
No, Your Honor.
to the motion?
I didn't follow anything in opposition either, Your Honor.
Okay, it's granted. Let me see the,
Here we go.
Proposed.
And the judgment.
Thank you.
okay. All right, let me hear from you as to what you're looking for in terms of a sale date, please.
Judge, the first sale date? Awesome.
All right, hold on. Yeah, I'll give you close to the first sale. It's gonna be March 18.
Thank you, Your Honor.
All right. So what are you doing in foreclosures in this particular? 30th? All right.
Judge, and I also have number 10.
Say it again?
I also have number 10. It's a motion. to
Okay.
amend.
All right, give me 1 second.
Yeah.
Okay. All right, number 10. And I'm assuming that there's no opposition either on this.
Correct, Your Honor.
All right, I'm gonna grant it. Let me see the order, please. All right, so okay. You don't have it today, the,
Correct. We'd just like to file it separately. We have a draft already done. We just kind of
okay.
want to do it as a separate thing.
Done.
Thank you.
Okay,
Good to
great,
see you.
thanks, likewise.
Number 2, wait, number 16, 1-6. Sir, man, that's you, number 16. Judge,
Good morning, Your Honor.
if I may, the
Morning.
young lady has a motion that she filed this morning, she wants you to read. Let me have it, man.
Okay.
Excuse me, I don't get a copy of everything.
This is your copy, sir.
I don't, you can't give it to me on the morning of the motion.
May as well, because I'm gonna read it. Do you have a copy of it or not? Let's see, is this an extra copy? Motion to vacate. The original was you filed it this morning, downstairs? All right, hold on, let me see. Oh. You don't have an extra copy for,
I have my copy.
all right, why don't you let him read that for a second while I read it.
This is the last case, by the way, except for the one that we passed.
Right. Okay.
Your Honor, with all due respect, may
Hold
I
on, let me read,
show you something else?
okay?
My brother has just passed away on December 30th,
Okay,
so I'm kind of feeling in a fearful state of mind.
okay, gotcha.
Sir?
Okay, have you had a chance to read it?
Yeah, she's talking about these alleged conversations with members of the
No, I
board.
understand.
They're not alleged,
My
sir.
question was, did you
Yes,
have
I
a
read
chance
it.
to read it?
Yes.
Okay, all right.
There's nothing alleged about them. I don't lie.
Okay. All right. So, let me hear-
This is our motion for summary judgment on foreclosure, Your Honor.
okay.
She hasn't paid since 2016. She was defaulted by the clerk. They didn't file a response to the original complaint or the amended complaint. She hasn't filed an affidavit in opposition to our motion for summary judgment. There has been no agreement, verbal or written or otherwise, for her to pay anything less than what she's supposed to pay. And the board has instructed me to go forward with the foreclosure.
Okay, all right.
First of all, it's totally untrue that I have not responded to anything. If you look at my whole docket, there's all my responses right there.
Okay.
And we have had numerous ex parte meetings. Myself and Armando, which is the president of our board. Your Honor, with all due respect, I do not lie. I have never been in the habit of lying. These are true statements that I'm making within these documents. We reached a verbal agreement, and this was on October 12th, hence the 2 emails. And when I didn't hear back from October 12th, and then late night of October 23rd going into October 22nd going into the 23rd, I said, I wonder what's going on. So then I looked on the website, and there was a notice of hearing scheduled, which I never got any kind of a notification.
That's not true, Your Honor.
It is very true, sir.
It's right here. Somebody received my notice. It's certified mail.
Right.
Somebody received it at the property.
Counsel,
That's for this hearing.
counsel, do me a
That's
favor,
for
please.
this hearing. I'm talking about.
Ma'am? Let's talk to the court, please, not each other. All right, now, it's been going on since 2016, correct? That there's been no payments?
Well,
Is that accurate?
yes.
Okay. It's now 2019. What's your situation?
I'm on disability. I've been in a hardship, and I was in a loan modification program that just ended at the tail end of February last year, and then that's when Armando and I had our first.
Hold on.
Meeting.
Was the loan modification, was it made permanent? There is a loan modification?
Yes.
Okay.
So then I had the means to be able to start paying my association fees.
And why haven't you then?
Because the condo management principal told me, and Armando was with him at their office, he said, we won't accept your payment.
Okay. Did he say why?
Well, he said, talk to our attorney, and I didn't get any kind of information.
And are you the attorney?
Yes.
From the beginning?
Yes.
Okay. Have you had conversations with him about this?
We had communicated via email, and I told him what my situation was. And at first, the amounts that they had, that they were claiming for my monthly payments were totally overstated. They were wrong. And I sent them letters to correct that, and I told them what my situation was. In the interim, this is when a lot of these ex parte meetings have occurred, because Armando and these
Okay,
were
hold
all
on 1 second. What's the total amount that she's behind?
Just on assessments, it's 29,000 plus 660 is about 30,000.
Okay. And how much of that do you have the ability to pay now? None? that correct?
I could have started paying my regular association fees. I had offered them an additional $200 a month, and this was back in October, what I stated in my email.
Right. Have you set aside, so you haven't paid the association's fees since you got the loan modification in February of 18, correct? You have not paid that, correct? Have you set aside in your bank account
Well, yeah,
those
I have
funds?
a little bit, but I also need to keep some reserve because my car is like 15 years old and it's been having mechanical problems. So I do have some money I can give to them, but up until now, there's been no response as far as me making an offer. The way it was left with me and Armando, the president, on October 12th, and this was by phone conversation, we agreed on $22,000. He said, don't worry about the attorney fees. And then he said, go ahead and write us a proposal letter and copy the other 2 board members, which I did. And that was my email you saw dated October 12th. So
Right.
in my mind, that was our agreement. And I was going to start paying that on November 1st.
But you didn't.
They never gave me a response.
As far as I know, Your Honor, there's nothing in writing, there's never been an agreement.
Oh, I understand that, but what do you know about her
I
conversations
don't know, this
the
was
board, with the
initially-
board?
Initially, before I filed the complaint, she emailed me, I passed on the offer to the board, and then I didn't hear from the board, and then the board told me, go ahead with the foreclosure because there's no settlement, she doesn't have the money. So we filed a complaint.
Well, one time in history, a man's word was his bond. So I took Armando's verbal agreement, I took that to heart, thinking that that's what we were going to settle on. Because we had been going round and round and round with this since March of last year, when I did offer to start paying them.
All right.
May I please
I'm gonna
have a
play-
couple of-
I'm going to place you under oath. Raise your right hand. You solemnly swear that the testimony you're about to give me will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right. What you put in this motion to vacate plaintiff's motion for summary judgment of foreclosure, okay? This document that I'm holding up that you handed to me earlier, is everything in that the truth?
Absolutely.
Okay. All right, here's what I'm going to do. Based upon that, I'm going to respectfully deny the motion for summary judgment. I'm going to request that you set this down on the trial calendar. All right? And we're going to have to go to trial. And if that happens, there's going to be serious problems because that's going to happen within a pretty short period of time. All right? So, if this doesn't get worked out, we're going to trial.
I've been trying, Your Honor, I've been trying. I've done all my due diligence as far as I could go.
All right.
Yeah, if you wanna send it to mediation. I don't know. But I mean, there's been no payments for 2 years.
I know. I know. I got you. I am going to do that. That's part of the second part of my order is, number one, it's denied. Number two, it's, I want you all both going right now up to the 18th floor and tell them that the court has just ordered. I'm going to give you a copy of an order that says you're going to mediation. All right? And I want this getting settled. All right?
Will that
You
mediation
better-
be today?
No, it's not going to be today. All right?
There's no guarantee that it's gonna settle.
No, I understand
There's
that.
never guarantees. She
No,
has
I understand that, but this is her, frankly, this is your last shot to try and get it resolved before it goes to trial, because if it goes to trial with what they say that they've got and what you've admitted,
But
it's not gonna be pretty.
with all due
So
respect,
get it done.
wasn't-
No, there's no need. I'm not hearing the trial now, today. So, let me go ahead and in the order put that it's, the motion for summary judgment is denied, that I'm ordering mediation within 30 days, okay? And that you're both to go to the 18th floor now and talk about, and get a mediator.
Can we get a center for trial already so we can have a trial date? We'll go to mediation first and then we already have a trial date set up.
That's a fair request, hold on. Did you talk to your client, counsel? Did you
Oh,
talk?
I'm sorry, Judge. Yes.
You did?
Yeah, I did.
Okay, well, hold on.
Yeah.
I just wanted to know.
Yeah.
Let me take care of this. All right, I've got one coming up in, looks like about 45 days, 50 days or so. It's April, take a look, you have your calendar? April 22nd at 9:30.
That works for me.
Okay. All right, ma'am, you writing that down? April 22nd at 9:30.
And this is
Here.
a trial?
This is the trial date. All right. I want you mediating before, by the end of March 31st at the latest. That's going to be the deadline. Okay, so put that in the order, and then I'll go ahead and sign the order.
And then go up and get a mediation date.
Yes, please. I want both of you going. All right.
Thank you.
All right.
I'm sorry, Your Honor, you said.
Do you want a copy back of this?
That's
This
his
is yours.
copy.
All right, counsel. That's your copy.
I'm sorry, sir, you said the 18th floor?
The 18th floor for
Okay.
mediation.
I'm sorry, I'm not firing on my cylinders
Sorry.
today. You have to excuse me, please. Thank you, sir.
Yes, ma'am.
Number two,
Your Honor, I did speak to my client, explain the situation. They're not really in a position or aren't agreeable to any kind of a rental. They need to get possession to repair the property. Apparently there's a lot of repairs that are needed and you need to resell it. I just wanted to reiterate the fact that this is, relatively speaking, this is, I think, one of the cases where there has been a fair amount of time for the people in possession to make arrangements to vacate. The title's been issued for over 4 months. My motion for writ was noticed 2 months ago. So.
Okay.
Can I say something?
Yes, sir.
Because even though the title was written 4 months ago during the summer, at that time there was no intention of selling the property. I even asked about rent. The landlord told me he doesn't want to charge me anything for rent because he needs to find a contractor to fix on the property. We brought numerous contractors to the property on countless times. I let them in to take whatever measurements, whatever. I always cooperated with them. When my wife lost her job before the end of November, I communicated and let him know these things. That's why when he told me, I need you guys, I'm going to sell the properties, and I said, well, I'm going to need a little more time because right now my wife is transitioning from one job to another. I said, right now, since I'm making all the money right now as head of the household, I'm going to need a little more time. You can't just come and say, in 2 weeks, you got to leave. Like, what type of...
The thing is, Your Honor, he kind of led us on in believing that he
The
was going to rent the property, so
the
we
entire
spoke with
duration
him.
while we was there, I would always communicate with him. It was all about, he wanted to charge us rent, but he didn't know exactly what he wanted to charge. Because I informed him that the house didn't have hurricane impact windows. It doesn't have central AC. The only thing it had was a new roof that my grandmother recently put on the house. And I even volunteered to use my own money to help him fix or whatever it was to take it out. That way it could get faster. He procrastinated with contractors. And then when he got to the point where he wanted to sell the property,
He ended up...
I said, okay, cool. I'm not mad that you want to sell it. Just give me a decent 90 days to find a place. Like right now, I just recently find a place, but it won't be ready until the 15th of March. That's why right now I just want a time frame to at least, if I got that window from here to the 15th of March, even if it's not that place that I have already waiting, I can look somewhere else to move. Because right now, during that time when he say, "Oh, do you have anywhere to go?" I say, "No, I have family members, but no one has space. Everyone's occupied. Everyone's space is full. It's not like I could go to a relative's house for a month and then me and my wife relocate from there." That was the whole reason why after it was said and done and my grandma died, the family was trying to fight to get the house, but there was no communication from the guardians down to the grandkids. So it was like I was stuck with the brunt of just dealing with the new owner. And once the owner came, I've been very cordial. I always cooperated with him. And like I say, it sucks that from the get-go, you telling me you want me to stay, you was ecstatic that, "Oh, I'm in the property, oh, I'm sorry your grandmother died, oh, keep paying the bills. I don't want to charge you and keep paying all the bills because I'm going to bring a contract in and start fixing things." And they never fixed nothing. All they did was just come in and take measurement at the measurement at the measurement at the measurement at the measurement. And that's why I told them at the time of December.
Here's what I'm going to do. Technically, legally, you all lose. Legally, technically, you lose. Okay? I am going to give them until February 28th, the last day in February. On that date, they're going to come in. That's a Thursday. I just looked at the calendar. That's a Thursday. Okay? Please, please, please work it out so that you all can be out by that date.
So,
Okay?
the sheriff shall execute on or after February 28th, Judge?
Yes.
Okay.
All right. So, and good luck to both of you.
Thank you.
Okay?
Thank you.
If you want to wait, I'll give you a copy of the judge's.
Good morning. 10:30, you work something out.
Oh, come on, Velez. You never. Oh, please. Don't tease me like that.
Tell me, do I work things out?
He's a mensch.
He is a mensch. That's true.
I sent you that last week. I'm trying to.
The question is, will she do it?
I think so, yes. I'm trying to show good faith.
Okay. All right.
Great. Thank you, Judge.
Thank you all. Yes, sir.
Let me have the Richard fucking make conference later.
Hey, Arthur.
Yes, sir.
This one we need to have copied also, please. Okay. All right. Don't leave without a copy of the order.
Okay.
Okay. So and keep the order there at your place. Okay. Yes, sir.
Me?
So what is this miracle that you and Wortman have
He and I have worked miracles before.
have worked out?
And he'll tell you that I've worked with him.
Okay.
He wants a judgment. I told him, take the judgment, and he requested it, give me a 60-day sale. And then I told him, I'm gonna send you a request for a payoff letter, and we will work it out from there.
That's fair.
Right.
That is. That's fair.
Let me tell you, the argument was gonna be over the fees, and I was gonna point out the invalidity of the statute, but I'll raise that another day. And I'll make law that I won't use this one.
You know, I knew there was going to be something.
Yes.
Okay.
It's always that constitutional argument.
It's not a constitutional, it's an equitable and.
I mean, I'm looking at, according to today's printout, it's April 1, April Fool's Day, wouldn't you know? April 1 is the sale date. That's 60 days.
That's 60 days.
Yeah.
That's fine.
And put it in there.
This is our proposed final judgment. Can I
let me
read on it or?
Can you what?
It's just, don't do that, because then.
Okay, that's fine.
You see, the fee issue was the item under $19,000 for filing a complaint. But I'm not gonna argue with him, because he's worth every nickel.
He is.
Ha, ha, ha.
I brought my.
And one day, he will hopefully say
You
that.
brought your expert with you? Is that what you
No, I
said?
brought, it's presumed reasonable, 3%. I have my time entries if you want to.
That statute is totally contrary to law. I can tell you that. It's actually
Well,
fraud on the.
maybe you guys can work it out.
No,
You know, as
we've
far as
done,
the
we've done.
numbers.
He can have the fees. I'd rather get him paid than he does this.
Sure, best of luck.
miracles do happen, I can be reasonable.
Let's see.
Is it fine?
All right, now, this, is this gonna be online, or is this gonna be a
Oh, it has to be.
sheriff's sale?
No, no.
Okay.
Yes, it has to. That's the only way the clerk will handle them these days.
Well, I've seen some exceptions.
No, the only one that still has those is the sheriff on levies
Right.
and executions.
You know what, I don't know, what's the
Website.
the website, is it realforeclose.com? That's my recollection, something like that.
Drawn and quartered copy.
What's that?
Drawn and quartered copy.
Yeah, drawnandquartered.com. Oh, www.miamidade.realforeclose.com. All right. Well, since your handwriting is always superior. Thanks, but
Oh, Mark's. Mark Cass's sufficient.
No, this is.
no, but that's right, because I mean, I recognize that as the website.
It's okay, no, it's correct. Thanks,
So
Brad.
it's
So-
Miami,
so
so it's Miami-Dade Real Foreclosure.
Dot.
Miami-Dade.realforeclose.com.
Another dot.
Yeah, another dot in between Miami-Dade.
Put a few extra W's in there. Mr. Cass gets it right, he's a Penn graduate.
He is, actually. He is, that's true.
Like my daughter.
That's great.
Like my son.
And
All right.
undergrad and Penn Law.
Undergrad. Oh, and law too. Wow.
Mhm.
That room. So is that part of it now crossed out?
You know, there's no room.
Because there is no.
There is no room.
There's a room.
Actually, daughter is a member of
What's-
Florida Bar,
no.
New Jersey Bar, New York Bar.
Well,
No, 3.
hopefully she's.
She has a
still
mother's
here.
brains, and she practices up in New York. And she finally quit the Wild Gottschall Show firm after 8
No,
years. She couldn't take it.
No.
Where's she in New York? Or?
In New York.
My uncle's a partner in DC at that firm, and I trust attorney.
He said, enough of Wild Gottschall.
He's about to retire.
And she went to a smaller firm. It's in the Chrysler building.
Be online.
That room, it just put online here.
Online.
Daughter got a complete trip at Vanderbilt and turned it down.
Undergrad?
And law.
That's a great school.
And
Does this close out?
yes, that will close it
Because
out.
you guys have, this is both on Garcia and SG 2901.
It technically doesn't, because we still have the request for the money jump. It doesn't, don't
Right,
you?
we have counts
There's an extra count, so
on the guarantor. but
can't SRS it technically, but we'll finish it out.
I'm assuming if we get paid, there's
That's it, that's
there's deficiency.
That for sure will close it out.
Talk about the expedited
Two
foreclosure
copies?
statute. This is like.
Oh, I know. I mean, on commercial, but only on commercial. Yeah, I mean, it's just, it is amazing. I've seen a bunch of them.
Daughter,
So,
we took daughter to the campus. We went
okay.
up and dropped off other daughter at Dartmouth.
Oh, at Dartmouth, okay.
That's the other one, the older one.
Because I was going to say, did you have her sit next to Benjamin Franklin on the
No,
bench?
we
or,
came back,
you know?
we found her
That
there
was-
with this pained look, and she said, I want to go here. He said, Elizabeth, you've got a free ride at Vanderbilt. She says, you pay for one Ivy, you're going to pay for another. So we paid for 2 Ivies and a law Ivy. You see why I worked so hard?
Yes. No, I feel your pain. I feel your
And I
pain.
still have enough to get my wife pearls.
My son's applied to, he's a senior at University School at MSU.
Oh, yeah.
And his #1 school is UPenn to go. And
That would be great.
he applied early
Okay.
and he got deferred.
Okay.
So he's still.
Well, but that's okay.
Yeah.
That's all right.
And his college counsel said that unlike other schools, those are actually real deferrals. They only defer like 20%. Other schools, will defer 80%.
Oh, wow.
So that's his #1. Ben Franklin is his supplemental essay.
So did he go see the play Hamilton? And
We didn't see Hamilton,
No.
but we were there and at Vanderbilt as well. And I say you can go to UF and get a full scholarship.
Oh yeah, and make it easy on mom and dad.
Eastern, right?
I know.
They're
I mean, both
giving
of
money,
I
a
know.
lot of money. I have one, so.
Wow.
Rice.
That's
So I'll
great.
buy
That's
you any
great.
car you want. You go to accept
That's right. You go to in-state, you get the you get the Florida prepaid college tuition.
thank you.
You get the scholarship. You get the extra money from.
Even Rice was really good. Okay.
Give them full boat.
Yeah, she turned us out.
That's another good school, especially for
That is
engineering.
a great school. Okay.
Thank you, Judge.
Okay, thank you
Enjoy your free
guys.
time
I
now.
appreciate it.
Yeah.
Wow, you just freed up a half an hour for me. Thank you all.
Now, the question is, why up here? This is a
Because,
tough elevator.
oh, I know. Because my JA and my bailiff deserved to move out of the postage stamp that they were in on the 10th floor.
Okay.
So,
Well, it's still the same elevator, because you really haven't changed.
well, that's true, but at least it was shorter. I mean, less time and less floors that could interrupt you. But yeah, you're right. You're right. All right.
Have a good one.
See you all.
Judge, if I may.
All right. Hi.
We went up to the 18th floor and they're saying that they need an actual order of referral with a schedule of fees. That they won't do it just based on the form order.
She wouldn't go.
Okay. Okay. Benita, do we have the mediation referral order? There's a standard mediation
It's a
referral
beige
order.
colored document.
That's because they printed it out on space.
Did they give it to you?
No.
I asked her, did she have one?
Yeah,
She
she
only
said
had
no.
filled out ones, for other cases.
Okay. Why don't you go around and ask Tanja,
We
who's
did.
my
She told me
JA?
to come in here, not the,
She doesn't have one either?
apparently not.
How can they not have,
He says speak to Judge Thornton, he'll know what to do. Okay.
She's
Yeah.
on the phone with someone too, so maybe she just doesn't have the moment to go and look.
But it's a standard order, I get them all the time in the mail.
Yeah, but
It says $60 or $120 depending on the income of the parties.
yeah, but how do they not have that on the mediation floor where that's where it's going to be done?
It comes from the judges, that's an order.
No, I understand that. I mean, I just don't know where to. Well, let's see if we can get Tanja to. Hold on, let me close out here.
Or you can make a power call up there and say, do it.
Yeah, I know. I'm not going to abuse the privilege. So let me see. Let's see if we can find out what's going on. Okay.
Thank you,
All
sir,
right.
for your patience.
Sure. No, thank you all.